All right, thank you for having me here. So 14 years ago, Steve Vladeck asked on Prof's blog, must Second Amendment originalism account for the militia clauses? I thought that was a fair question, and my attempt to answer it has now spanned 3 papers across 5 years. The first 2 papers laid out the original understanding of the Army-militia divide, explained how that divide gets translated into the modern bureaucratic structure of the armed forces, and then the second paper explained the relevancy of the militia to the armed forces as it exists today. And with that background in mind, the paper I'm presenting here sets about how to reconnect a broad individual right to bear arms to the militia system. So this paper seeks to make 3 contributions to the Second Amendment debate. First, it rehabilitates and defends what was once the standard theory of the Second Amendment, that it secures at least an individual right to keep and bear arms for common defense. Second, the article grounds the Second Amendment in the Anglo-American amateur military tradition. And third, the article attempts to engage in heavy conceptual cleanup of the Second Amendment debate, particularly in reference to properly defining what constitutes an individual versus collective right. And to avoid confusion, I'm going to begin this presentation with the conceptual cleanup and then move to what I think are the 2 bigger contributions. So at present, the academic and judicial debate over the Second Amendment's meaning has reached a stalemate. On the one side of the debate are the individual rights scholars who argue that the Second Amendment secures a right of individuals, including those not presently enrolled in an organized militia, to keep and bear arms for individual self-defense against crime and for the resistance of tyranny. On the other side of the debate are the collective rights scholars, and they argue that the Second Amendment has nothing to do with individual self-defense, that the amendment either grants to states the right to maintain their own military forces, or it grants to individuals formally enrolled in well-regulated state military forces the right to keep and bear arms. Now, despite these supposedly well-recognized camps, inconsistent use of terminology has, I think, introduced confusion. So Justice Stevens, in his Heller dissent, for example, purports to agree that the Second Amendment secures an individual right. And for those familiar with the Second Amendment debate, the book by Winkler and Merkel do the same thing. They try to say they're bridging it by creating an individual right for militia purposes. I disagree with their characterizations of their theories as individual rights. And individual rights scholars themselves also struggle, I think, to demarcate where the individual right is. So my paper is not the first to articulate an exclusively public defense theory of the Second Amendment, and individual rights scholars frequently refer to it as a hybrid theory, as though it's kind of halfway in between an individual and collective right camp. And so to clean this up, I argue that what distinguishes collective rights theories from individual rights theories is the belief that individuals must satisfy 2 conditions in order to be vested with a right to bear arms. The first condition is some form of prior authorization from the government. And that could come either with an explicit directive that individuals have to possess arms, or it could come through a directive enrolling them in a well-organized military force. The second central claim of the collective rights view is that the right to keep and bear arms is bounded by necessity. Only those arms that are necessary for individuals in the militia to perform their official duties, and individuals only have a right to private arms if the government does not adequately supply the arms. Consequently, I think there are really 3 theories of the Second Amendment overall, including 2 species of individual rights. So the first theory of the Second Amendment is that it's an individual right that enables personal self-defense against crime. The second is that it's an individual right that provides for common defense by enabling resistance to invasions or oppression. And the third is that it guarantees the existence of state military forces, either by granting states the power to arm their military units or by granting individuals in those units the right to keep and bear arms. But for the purposes of this paper, among the central claims, I think, is that we have to analytically separate the first and second theories. So both are individual rights theories. They do not share the requirements of governmental authorization and necessity, and so they are not compatible with the traditional collective rights claims. Granted, they theorize the right differently, and I think by theorizing the right differently, they will have somewhat different scope, but they are still within the individual rights camp. Second thing to keep in mind is that the second theory does not entail the first. The first theory is compatible with the second. You can have an individual right for both common defense and private defense. But the truth of the second theory does not entail the truth of the first. And correlatively, separating the first and second theories also explains why many collective rights arguments are non sequiturs. So Justice Stevens in his Heller dissent purported to deny the individual right by rejecting Justice Scalia's focus on individual self-defense. But the denial that the right to bear arms protects private self-defense against crime does not establish the truth that the right is conditioned on prior enrollment in the militia. Switching now to the positive theory, this article takes the position that the second theory is undoubtedly correct. The Second Amendment secures an individual right for common defense. The article is agnostic on the first theory, and its central claims are compatible with the individual self-defense view being either true or false. This view is, however, incompatible with the collective rights view as it presently exists. And so what does the Second Amendment protect under this theory? It protects the right to possess common military arms in the home, to carry them abroad for training and public defense, and incidental rights necessary to make them effective, such as the right to purchase arms and ammunition. Now, I only have 10 minutes to speak, and I have a lot to say, so I can't flesh this claim out with specificity. And in fairness, I don't do it in the paper either. But I think serious discussions about the right to bear arms have a way of getting sidetracked by arguments that if the right protects military-type arms, then it will secure the right to own tanks, missiles, cannons, and nuclear arms, and that because this is absurd, the underlying theory is absurd. And I don't think the validity of the theory is so facilely defeated, and let me give two brief responses. First, although the theory claims that the arms protected by the Second Amendment are military arms, it's not saying that every military arm is protected. And so we were talking yesterday, Charlie suggested I should rename the paper Nukes, Not Knives. It's not all arms in the military arsenal. And second, even for those arms that do fall within the protection, states still have a police power to regulate those arms. It's not an unlimited right to possess them. The state can't prohibit individuals from possessing the arms, but they can regulate to a point. They can regulate the arms to a point and their accessories. Last contribution is that this article grounds the Second Amendment in the amateur military tradition, not in military federalism. Collective rights theorists frequently argue that the Second Amendment is a federalism provision that secures a state's right to military forces against fears of a national standing army. In making these arguments, collective rights theorists confound state armies with non-professional armies. A militia is not a state army. The essential attribute of the militia was that it comprised citizens with civilian occupations who could be called into temporary military service. And it stood in contrast to an army of regular soldiers, those whose principal occupation was warfare. Framing error objections were not leveled against national armies. They were leveled against standing armies. And the Second Amendment countered fears of military professionalization. The Second Amendment responded to those fears by preventing the government from investing any armed factions with a monopoly of the tools of violence. The Second Amendment protects citizens against armed factions. It does not, as the collective rights view maintains, protects armed factions against legislation by civilians, a claim that if it were seriously accepted would imperil civilian control of the military. And I'm running critically low on time here, so let me just say two other things very briefly. I think understanding this also explains how the Second Amendment fits into the broader picture of general law. The Second Amendment was not the only framing-era constitutional provision to secure a right to bear arms. Many state constitutional provisions did this as well, and collective rights theories have problems explaining the state constitutional provisions. This theory explains not only the state constitutional provisions, but also how they comported with those provisions, how you can reconcile them with the provisions which also contain declarations in the state constitution against standing armies. At bottom, the individual right for collective defense theory recognizes that the Second Amendment secures the institution of amateur soldiery, an institution that remains alive and well. The existence of amateur soldiery and the keeping of regular forces to the minimum size necessary are critical components of preserving civilian control of the military while maintaining adequate national defense. Ultimately, the Second Amendment's importance in preserving the amateur military tradition is not diminished by the federal government's seizure of operational control over amateur forces from state governments.
The most important test of an article's merit at an originalism conference is whether the analysis and conclusions accurately represent the original public meaning. On this scale, I believe Roberts' article is a resounding success. In contrast to the dominant theory of the Second Amendment in the courts after Heller, Roberts' approach has the advantage of centering the original public meaning of the Second Amendment on the actual concerns expressed by the framers during the period of ratification. There is little doubt that elements of personal self-defense were present in the English common law history of the right to arms, which we see in the work of Blackstone and other writers of the time. But the ratification debates over the Second Amendment are conspicuously lacking expressions of that particular view of the right. The records do not show any of the kinds of arguments we might expect to see in support of a personal self-defense understanding of the right to keep and bear arms, such as complaints that the streets were unsafe or that people needed to be able to defend their homes and families from common criminals. The closest we come are occasional statements in the ratifying debates and state constitutional provisions that the right to arms served the protection of, quote, themselves and the state. And this might be support for a personal self-defense understanding. Or it could plausibly and alternatively be understood as another way of saying common defense, that themselves means the people as a whole defending their democratic liberties from tyrannical government or invasion if the state goes bad. This second understanding would be consistent with the extensive and pervasive discussion we do find in the ratifying debates, that the right to arms was necessary for common defense of the people's democratic liberties. As Roberts' article details, this was how the Second Amendment was understood by the public that debated it. A virtue of Roberts' piece is that his common defense understanding of the Second Amendment makes better sense of the text of the amendment. The personal self-defense theory has to do considerable work to make sense of the prefatory clause, and Justice Scalia's claim in Heller that preserving the militia was just one of the many reasons the founders guaranteed the right to arms remains hard to square with the ratifying debate's exclusive or perhaps nearly exclusive focus on common defense. Under Roberts' view, all the language makes sense, all the language of the text makes sense and would be understood by the ordinary reader to say pretty much exactly what it says, but maybe in a slightly different order. The right of the people to keep and bear arms shall not be infringed because a well-regulated militia is necessary for the security of a free state. Roberts' common defense understanding of the Second Amendment leaves a number of key questions unresolved, however, and I'm sure Robert himself would admit, and to which I have little doubt that Robert's already working through future scholarship. I wish to focus on two categories of unresolved questions. First, questions about the scope of the Second Amendment, and second, questions about originalism, especially with regards to the Second Amendment. With regard to the scope of the Second Amendment, Roberts' article does not fully grasp grapple with how lawmakers and judges should address personal self-defense. As he says in the article, and just said a moment ago, that his theory is agnostic about whether the Second Amendment also protects a right of personal self-defense against common criminals. And he suggests in passing that it may be consistent with such an argument, but he does not take a strong stand one way or another. This is, however, a vitally important question, especially for courts applying the Second Amendment, because the scope of the right might be very different if we include personal self-defense or if we exclude it. Common defense is fundamentally political, preserving the health of a democratic government or nation. Self-defense is fundamentally personal, preserving the health of ordinary individuals in the event of confrontation. Without knowing whether the right extends to personal self-defense, we're left uncertain as to what the Second Amendment covers and how courts should apply it. Government regulatory authority, for example, may be quite different under a common defense view of the Second Amendment than a personal self-defense view. If common defense is at the core of the Second Amendment, then one might imagine the government to have significant regulatory authority to restrict firearms in the home, for instance, where it is not ordinarily used for military purposes or training, but primarily used for self-defense. Switzerland today has a citizens' militia, and military-style arms are commonly owned and often provided by the government. But those arms, because those arms are primarily understood to be for military use, not personal self-defense, those firearms are mandated to be locked up at home with their ammunition stored separately. Determining the extent of government authority requires us to figure out what the original public meaning of, quote, well-regulated is. And I think that question still remains unanswered after Roberts' paper. Some argue that well-regulated only means that the armed citizenry should be trained and disciplined, not regulated in the modern sense of controlled and shaped by government. Robert, however, seems to endorse the latter view, the more modern sense of controlled and shaped by government, that regulation, he says, means being subject to rules. That view has the benefit of consistency with other provisions of the Constitution. The Commerce Clause, for example, refers to Congress's power to regulate interstate commerce, and it would never make much sense to talk about the power to train and discipline commerce. So clearly the framers understood regulation to at least have the potential to mean more. Regardless of which definition of well-regulated we adopt, this language recognizes a measure of government authority that is unusual in the text of the Bill of Rights. And if the militia is not regulated, as ours arguably is not, and especially not well-regulated, then it may be that current patterns of gun possession and carriage do not further the Second Amendment's underlying values. Even within Roberts' theory of the Second Amendment, core issues like which arms are protected, when is public carry protected, and who decides what is in the common defense remain ambiguous. Roberts says that the arms protected are those commonly used for military service. And I think he's right to say that doesn't mean nuclear weapons or tanks. But soldiers do today commonly carry into battle machine guns, AR variants that have selective fire. That is, they can be switched to fire automatically. And hand grenades are pretty common, too, as part of the soldier's basic set of equipment. Current doctrine permits the prohibition of common military weapons because under the personal self-defense theory of Heller, what matters is whether the arms are in common use by citizens for self-defense. But the common defense theory says that that's the wrong way to think about it, and what matters is common military use. If so, then we may have to flip Second Amendment doctrine in very significant ways, permitting machine guns, but as Robert notes in the piece, perhaps allowing the prohibition of small handguns, which are uncommon for the ordinary soldier. With regards to the where questions, the common defense theory requires people to be able to carry arms for training and, of course, when engaged in the common defense. And that understanding is consistent with how Americans tended to talk about the right to bear arms in the founding era. While Heller emphasized a handful of statements from the founding era that used the language of, quote, bearing arms in a non-military context, like hunting, the corpus linguistics databases that are available now, that weren't available when Heller was decided, show that nearly all references, the numbers vary from 85 to 92% depending on the database, refer to bearing arms in a military context. One benefit of the common defense understanding in this regard is that it provides a better justification for the current doctrine's allowance of restrictions on arms in sensitive places than the personal self-defense theory does. Guaranteeing a right to carry arms for military-related purposes, including training, does not necessarily mean individuals have a right to bring their guns wherever they want into schools, government buildings, or places that serve alcohol. People can train elsewhere, and some places may be deemed inappropriate for training purposes. In contrast, the personal self-defense theory doesn't explain the sensitive places doctrine because one's need of a firearm for self-defense does not change in schools, government buildings, or bars, absent comprehensive security. Another question about the scope of the Second Amendment raised by the common defense theory is who decides when common defense requires the bearing of arms. Robert is at pains to show that this is an ordinary individual right, but individual rights, traditionally understood, recognize the inherent ability of individuals to make their own autonomous choices about when to exercise that right. But do individuals have the same right to choose when to take up arms in the common defense? Say, if they fear an invading forces of undocumented immigrants or fear the tyrannical government that imposes mandatory health care. The common defense theory also raises important questions about originalism in the context of the Second Amendment. One question is how we should think about rights today when those provisions in the Constitution are based on widely discredited understandings about the nature of society. Robert shows convincingly that the framers thought the Second Amendment was necessary because of their fear of a standing army and faith in the usefulness of a citizens' militia. But they were wrong about standing armies, which, contrary to their belief, are not inherently corrupt, partisan, or disruptive of liberty. Nor are armed citizens particularly useful for common defense of the nation and of their liberties. While the existence of an armed populace may discourage tyrannical government, to be sure, experience shows that citizens' militias were unreliable tools of national defense. That's why we don't rely on them and haven't done so for nearly 2 centuries. Another question is how should we understand rights for which there were multiple, potentially inconsistent public understandings at the time of the ratification? Imagine if we knew that 40% of Americans at the founding thought that the Second Amendment was about common defense. Another 30% thought it was instead the more Blackstonian personal self-defense, and another 30% saw it as primarily a federalism provision. Assume each view was exclusive of the others. Courts adopting any one of those theories would be democratically deficient. Whatever particular understanding was adopted never gained the supermajority support that constitutionalism demands. Adopting any one of those theories at the exclusion of the others means denying what a majority of people understood the provision to mean when it was adopted. Adopting all of the theories together only multiplies the problem, giving excess weight to each individual theory when none had supermajority support. An originalist would not countenance popular rewriting of a constitutional right. It should mean the same today as it did when ratified. But the right to keep and bear arms has had an unusual history, one that challenges the common defense understanding of the Second Amendment. The right to bear arms has been not liquidated, but in some ways transmuted over time, undergoing a significant change in the nature, substance, and form of the right, from common defense to exclusively personal self-defense. Virtually every state constitutional provision on the right to arms has been interpreted to preserve arms for personal self-defense, with common defense marginalized or ignored altogether, even when the text of those provisions signals support for a common defense view. And we already know about how the Second Amendment has been recentered to emphasize personal self-defense. If this were merely a matter of living constitutionalism, this transmutation could be easily dismissed as illegitimate. But again, the Second Amendment is different in ways that pose unique challenges for originalism. When the 14th Amendment was adopted, in part to incorporate the Bill of Rights against the states, supporters expressed support for a view of the right to keep and bear arms that rested primarily, although not exclusively, on personal self-defense. They didn't emphasize common defense. The main purpose was preserving the freedmen's right of personal self-defense against prohibitory laws like the Black Codes. If so, it may be that the 14th Amendment's ratification fundamentally changes the scope and meaning of the Second Amendment right. Or alternatively, if we were to conclude that the 14th Amendment could not transmute the meaning of the Second Amendment in this way, then a committed originalist may have to accept that the meaning of the right to keep and bear arms is different when applied to the federal government than it is when it's applied to the state and local governments. In other words, there may be two rights to keep and bear arms, one centered on common defense that restricts the federal government, and one centered on personal self-defense that applies to the state and local governments through the 14th Amendment. Thank you.
Thank you. That was great. I think I agreed with virtually everything in the first 6 minutes, and then started having significant disagreements from there. So I think everything you said in the beginning was right in terms of how the scope of the theory of the right affects the scope of the right, and you will have two fundamentally different rights depending on whether you think common defense is at the core or at least part of the core, or if it's individual self-defense only. And we're seeing this now in the cases where the cases are finding that there's a constitutional right to have a switchblade knife but not a semi-automatic rifle. And I think we see it, Adam did a great job in his articles of laying out what the reasonable regulation meant under state constitutions. But all of those cases are predicated on ignoring the state constitutional provisions which guarantee a right to bear arms not just for individual self-defense, but also common defense or defense of the state. So what reasonable regulation is, I think, depends heavily on the teleology of the right, what function the right is designed to serve. Let me pick up, since I only have a limited time for rebuttal, the military stuff's the one thing I had to cut on my initial presentation, and I'm going to pick it up here. So I think the view that the militia system has disappeared, and because it has disappeared, therefore we have to reorient the right, is fundamentally mistaken, and that was the subject of the first two papers. So as I said at the beginning, the core distinction between the Army and the militia was in the nature of service. Armies were regular forces, full-time soldiers. The militia involved individuals temporarily called to service. And at the framing, the structure between armies and militia looked something like this. You had in armies, you had the standing army, which were the soldiers who had contracts that existed both in peace and in war. You had wartime enlistees. And then on the militia side, you had the volunteer militia, which are people like the Minutemen, people who volunteered for service, would undergo extra training, and were the front line of defense. And then you had the general or common militia, which was just the entire remaining able-bodied population who could be called into service. And sometimes they trained a little bit, sometimes they mustered and drank, and sometimes they went 30, 40 years not training at all. And then in between them, you had a de facto category called the war volunteers, which was not a legal category, but they were basically militiamen who pretended to act as if they were regular soldiers. And if you translate that to today, today's bureaucratic structure is much more complicated. But I think the constitutional armies in Article 1, Section 8 are what today we would call the regular components of the non-naval armed forces. The regular Army, the regular Air Force, now I guess the regular Space Force. And I have a question on the Marine Corps because I think the Marine Corps' substance has ebbed and flowed depending on whether they were attached to the Navy or operating as a de facto second land force. And then the National Guard and those types of organizations, I think the active National Guard and the active Army Reserve are the modern descendants of the volunteer militia and the war volunteers. And then the general militia and war volunteers are a bunch of inactive military components. And then I think the modern general militia today are the people who would register or could be registered with the selective service system. These are the able-bodied individuals who constitute the military force of last resort. And so my argument in this paper is that the Second Amendment preserves the amateur military tradition, and that tradition is alive and well. The not regular forces continue to be the backbone of the armed forces. We just do not have the resources to rely exclusively on regular troops. We don't rely exclusively on regular troops. And I unfortunately had to cut from the paper the last section which connected the Second Amendment to the militia as it exists today. But I think the fact that all we were require of the modern general militia is registration doesn't mean they somehow fall outside the scope. If anything, the Second Amendment's more important. And in the next paper, I will explain what function it serves, but my kind of 30-second summary of this is that by securing an individual right to keep and bear arms, it allows individuals who aren't being disciplined by the government to train on their own. It allows them to acquire arms, and it helps society maintain a dynamic arms industry, which otherwise would collapse in profound periods of peace. And so I don't think that there's anything about the lack of training that has made the Second Amendment obsolete. And in fact, there aren't, even though the federal government supposedly supplies the arms, there are not enough arms in the public arsenals if we had to expand the military greatly, say if we went to war with a pure threat like Russia or China. There just aren't enough guns in the armed forces arsenal to properly equip everyone. So I still think that there is a function that is applied, that there is still a live function for the Second Amendment that doesn't amount to preparing to overthrow the government if it's tyrannical, and also is not reducible solely to individual self-defense. I think I'm out of rebuttal time here. I have some other things I could get into. Corpus linguistics, I think, also demonstrates why those who say that bear arms has a military connotation, that doesn't sustain the truth that it's a collective right. I think the people who have stated that have overclaimed. There are some other things there are some other things I guess I could get into, but I want to hear your questions as well.
Terrific paper. I learned a lot. I was persuaded in many respects. I think it's an extremely important contribution because it helps address the kinds of weapons issue and the purpose for which we have weapons, including AR-15s and others, in a way that the self-defense, the personal self-defense theory or purpose does not. So, huge contribution. I want to just push on the fact that the paper expresses agnosticism about the personal self-defense right. It doesn't say it's not there, just is agnostic about it. I want to push you on that a little bit because I think the enumeration in the Constitution of a common defense right should not be construed to deny or disparage an individual right, as if there is such a thing as an individual right. And I think clearly, A, we are not supposed to rely solely on the letter of the Constitution to determine the content of the law. I've learned that. And B, we could resort to the general law, or in Judd's view, the natural rights, which pre-exist the formation of government. And there's nothing more fundamental. There is no more fundamental natural right than the right of personal self-defense. Now, is that also part of the general law? I wish I knew more about that, but I did ask Rock to tell me which state constitutions have provisions of this sort, and 7 state constitutions protect right now. I didn't ask them to go back at the founding, but you know this language goes all the way back. 7 constitutions have in defense of themselves and the state, or in defense of himself or the state, or in defense of himself, their families and their property in the state. 4 states are just limited to common defense. And that doesn't prove that one is the right meaning or the other, but it certainly makes it available as a possible part of the general law that pre-existed, in addition to the natural right of individual self-defense. So therefore, all that would be necessary to modify your proposal, as I understand it, is not to come up with an independent second right, an unenumerated right to keep and bear arms. No, the right to keep and bear arms is there in the text. All that's necessary by appealing beyond the text is to add this additional purpose for which one has arms. The one that is more expressed by your reading in the text of the amendment, and the one that is more even more fundamental than that right, which is the right of personal self-defense.
So I was having some trouble with figuring out exactly what the thesis is. So around pages 4 and 5, you say something like, you're claiming that there's an individual right to keep and bear arms for the defense of the community. So I get that that's your thesis statement, but I was having trouble sort of putting flesh on those bones until like around page 11 or so. Like, what exactly does it mean to have an individual right to keep and bear arms for the defense of the community? Then at page 11 and onward and various other places, you say something like, okay, it's securing the existence of people who can serve in the militia when called up. and it's reducing the need for professional forces, and it is deterring the improper use of standing armies. So now I'm like, okay, I think I have the thesis, and the thesis at least involves like my dad's theory of the Second Amendment, which is that if the government tries to do something really bad, I can just overthrow the government with my guns. And that's fine, like if that's your theory, but now, so I thought I had it. And then it sounded like you were explicitly disclaiming that just a minute ago, and I don't know what to make of it, because it seems, I could just be totally misunderstanding, but it seems to me that there are parts of the paper that imply the, like, we can overthrow the bad government, you know, if we really need to theory. And I would just appreciate a little bit more clarity about whether you are or are not arguing for that. I guess I got the impression that that is your view, but you're trying to kind of cover it up for like law review submission purposes. And I just figure they're going to figure it out anyway, probably, if that is your view. So,
Robert.
Yeah, so they may be figuring it out because I'm having trouble getting the paper accepted. Let me go in reverse order here. So what is my thesis? My thesis is that it's an individual right that is for military purposes, so that the core of the right is to have military-type arms, to possess them, purchase them, train with them, and to carry them for public defense activities. Part of the thesis then is justifying why this should be the case. And yes, I accept the fact that the framers thought that if the government became oppressive or acted in a way that, as the Declaration said, not just unconstitutionally, but with a train of abuses, that there is some reserved right in the people to alter it. I mean, Hamilton says the same thing in Federalist 28. But I think single-mindedly focusing on this misses the bigger picture. The amendment's doing more than just enabling that sort of self-defense of the community as a last resort. And what it's doing is it's allowing the citizenry to obtain military knowledge under the theory that by having a community that is trained with arms, you can pull people into temporary military service when military exigencies require them. They can go do the terrible things that soldiers do, which are fundamentally inconsistent with normal civilian government. I mean, when you're in the military, you're killing other human beings. And then discharge them back into civilian life. And by doing this, you reduce the need for regular forces. And regular forces are problematic for society because they are a separate society that doesn't share in the civil liberties that everyone else has. They exist under military law. They have their own code of laws, their own officers, and their own peculiar interests. And contrary, I think I disagree with Adam that the concerns about the standing army are very alive and well. I mean, during the transition from President Trump to President Biden, Speaker Pelosi called General Milley and asked whether he was going to get involved in the political dispute. And I think that betrayed the fact that there was some concern among the Democratic Party that the military may not remain neutral, that having this armed constituency is something that we have to control. And if you look at various laws like the Posse Comitatus Act and the Goldwater-Nichols Act, we don't take for granted that the standing army will always be compatible with democratic government. We take extensive prophylactic efforts to control it. So I don't think the framing error concerns about the regular forces have passed. Now, on Randy's question, I think, so there are a couple of things that I want this article to do. You're right that I am agnostic on the individual self-defense. I only get 30,000 words, and I think the individual self-defense requires its own special justification. But there are a few things I want to do. I want to say that the legitimate debate in the original public meaning of the Second Amendment is between people who subscribe only to the second theory, the civic Republicans, and those who subscribe to both the individual self-defense and the civic Republican. That the collective rights people are flatly wrong, and so are the federal courts after Heller, which is an exclusive individual rights view. On the individual right itself, I think there are three questions, and they're all difficult. Number one is, what is the original public meaning, both of the right, the right doesn't have to be limited by the prefatory clause, and here general law and the unenumerated right of self-defense, which is surely one of the rights retained by the people under the Ninth Amendment, would factor in. A second issue is liquidation. I think there's also a strong argument that to the extent that it was ambiguous whether individual self-defense was protected, that it clearly liquidated in favor of individual self-defense with the history that Adam was referring to up to the 14th Amendment. And I think the third thing to keep in mind is the distinction between individual and collective defense isn't as bright as we make it out to be today. So in English common law, the right of self-defense actually comes fairly late. You don't actually see it until the 19th century. Before then, acting in self-defense would have been considered a law enforcement function, the prevention of a forcible and atrocious felony. And it would have been justified on its public law enforcement rationale. And so, this is reflected too in the modern structure of criminal law defenses. Actions that are justified as individual self-defense are often also justified as acts of private law enforcement when people use deadly force to prevent a forcible felony. So I think the idea that individual and self-defense are widely apart isn't quite right, that there is a strong history in the Anglo-American regime of authorizing citizens to act not just in a military capacity, but also in a law enforcement capacity against those who are breaching the public peace.
I'm worried about the agnosticism, like Randy, but in the opposite direction. We have a text. What's the original meaning of the text? I'm very persuaded by your view that there's an individual right of collective self-defense, or is that how you put it? The individual right of, collective self-defense. Very, very persuaded. Your agnosticism left me a little cold, I guess. The main argument for it, not just what you gave right now, but in the paper, seems to be the point about the First Amendment. The core of the First Amendment might be political speech, but that doesn't mean it doesn't cover other stuff too. But we don't have the prefatory clause in the First Amendment comparable to what we have in the Second Amendment. So I just wonder what you think, if you're not any sort of living constitutionalist, but if you're just an originalist, what would have to be true to make it the case that the Second Amendment right is not just two, but is two and one as well? I take Adam's point that there are somewhat differing views, but generally public meaning originalism is supposed to take the dominant view. You're sort of counting up noses, and if you get over 50%, then sort of that's the view here. And it just seems that based on all you've said, you've quite persuaded me that the understanding, or the meaning of the original understanding and meaning of the text was number two. So I'd like to hear a little bit more about what justifies the agnosticism. And there was something more I was just about to say about that. You might help yourself to an individual right of self-defense as a privilege or immunity of citizenship, some sort of unenumerated right that way. That strikes me as more plausible. But I just worry about why you don't seem to have the courage of your historical convictions, which would be to stick with. So I know what I was going to say. Can you just say a little bit more about the nature of a core and periphery analysis? What is at stake when you say the core of the right is X, but the whole right might include Y? What is the notion of core and not core doing for you there?
So Mitch's comment suggests to me that it would be a good idea early in the paper to lay out the issues that you are reserving for future papers. So I think you are reserving for future papers the relationship between the natural right to self-defense, the Ninth Amendment, and the Second Amendment. I think you are reserving for future papers the meaning of the privileges or immunities clause of the 14th Amendment, and what right the Privileges or Immunities Clause covers. And if you laid that out clearly at the beginning, I think it would avoid a lot of misunderstanding and explaining why you're, I don't know why you are agnostic, but that would explain why you're not dealing with the individual right question in this paper. I have a suggestion, which is if you wish to explain how your theory is part of the communicative content of the Second Amendment, there's a very easy way to do that. That is that in light of the so-called prefatory clause, there is a pragmatic enrichment of the so-called operative clause. That pragmatic enrichment is exactly what you say, that is, there is an impliciture for the common defense or something like that. You'll get the precise formulation right. That is, you have an easy explanation as to why it is that your theory matches the actual content communicated by the text of the Second Amendment to the public at the time it was framed and ratified.
Elon.
Great. Three quick things. Number one, Robert, I've said this before, I love this paper and all the papers you've done up to it. I mean, very few times you read something and it just totally changes how you think about something, and your papers here have. And if I may suggest, in the spirit of that, you could do better at marketing in the sense of, how about calling the paper the Red Dawn Amendment or something like that, which is ultimately, I think what you're saying is, yeah, tyranny against government tyranny, that's an incidental benefit and so on. If it helps with an individual right to self-defense, that's also incidental. But the real purpose is, why does Congress call forth the militia? To suppress insurrection, repel invasion, execute the laws of the Union. It's to help the government. It's to help the government survive, you know. And so I think if you, but that's your previous paper, I think, had more to say about that. So that's just a suggestion as to marketing. Just sort of embrace that you're reconceiving how we're all thinking about the role of the Second Amendment a bit more, in a more marketable way, and that's one suggestion. Let me say something about the agnosticism. I get the agnosticism. It makes total sense because, of course, under the original meaning of the Constitution, there is no plausible way to read any provision to say that Congress had power over personal guns in the home, right? There's just no enumerated power. Okay, maybe there's some problem in DC or something like that, right? But it's just totally implausible, and the only reason this is an issue today is because of modern readings of the Commerce Clause. What did Congress have power over? Regulating the militia, and so it's going to regulate arms related to the militia. That's why you should be agnostic about it, because they were. This was totally irrelevant to them. Now, the 14th Amendment is different. It applies to the states, and obviously the personal right to bear arms is a privilege or immunity of citizens. So if you want to bracket it that way, that's fine, but I totally get the agnosticism, because it just seems totally irrelevant to the original meaning of the amendment. Just if it's not in the Second Amendment, it doesn't mean Congress had the power over that thing anyway. And then finally, let me say something about the nukes. You've heard this before, but I don't think you need to rely on the police power. And let me say two things. One is, I mentioned it to you before that rarely you have a student who writes like what seems like a really brilliant paper. I had a student at Arizona State who basically said that, well, today in military parlance, arms actually means personal arms, things that you can carry on your person, and ordnance, there's like no I in there, ordnance, it's like artillery, cannon, nukes, tanks, things like that. And actually, if you go back to the 18th century, there's no, when you look at definitions of arms or manuals that talk about arms, they don't talk about those other weapons. Those other weapons are talked about in ordnance, so that's one possibility. Another and this has not been published before, which is why I'm really pushing the student to like get his act together. He's graduated now, but still, to publish this. And the other is, why can't bear be additive in the sense you have to be able to bear the weapon in order to also keep it in the home? Or why do those have to be separate?
Yeah, So I would add to what you just said, Alon, too. I think there also should be some reference between the arms and the purposes of the militia clauses. Nuclear arms are not appropriate for enforcing the laws or suppressing insurrections, and we almost certainly wouldn't use them for repelling invasions either because of the nuclear fallout. So I think there are a few ways. You can look at BEAR, you can look at the meaning of arms, and you can look at the purposes for which you call forth the militia. And I guess you could also look at the tradition going back to the assize of arms in 1181 of what arms English law and later American law required. So, yeah, so I guess I'll go in reverse order again. I think Alon, or actually let me go with Mitch and kind of synthesize Alon. I'm agnostic not because I have no views on this. I happen to think the individual self-defense rule is probably correct. I'm agnostic on it in this paper, I think, for two reasons. One, I'm up against pragmatic space limitations, and I'm at 30,000 words now, and to properly justify an individual right for self-defense would take me far above that. And I think, two, is the kind of justification that would be necessary to sustain the individual self-defense view is different from the kind of justification that sustains the common defense view. As Adam noted during his presentation, there's a lot of discussion about the standing army and fears of the standing army. There's virtually no discussion about personal self-defense, and all of that has to be reconciled. And one way to reconcile that, as Alon notes, is perhaps they didn't fear prohibiting weapons for individual self-defense because there was no enumerated power outside of the territories to do it. Another might be they didn't really recognize the hard distinction between individual and common defense. They might have thought it was all common defense, and you could call the posse out if you need to. Third, in terms of the why it matters, why the underlying purpose matters as much, I mean, I think this actually gets back to an area where I was kind of prodding with Sharif earlier, that I think the purposes matter quite a bit, not necessarily just for the public meaning of keep and bear arms, but also for the scope of the police power to regulate the right to keep and bear arms. So, I mean, I think Bruin is right fundamentally in its two steps, even though I think the court at this point is allergic to hearing a two-step test when it comes to the Second Amendment. But I think the first step is to ask, is the conduct protected at all? And if it's not protected, then the government has free rein to regulate subject to other constitutional limitations. I think if the conduct is protected, it's not an automatic trump. At that point, it becomes a question of how extensive is the state's police power to regulate the right. And I think the question, I don't think it's just quite balancing in the abstract. I think there's more to it than that. And I think one of the questions of whether it's a reasonable exercise of the police power is, does it infringe the core of the right? If you infringe the core of the right, it is not a proper exercise of the police power, even if you're regulating for a proper purpose. And so you have to understand the core and the periphery, because in the periphery, the government might, in small cases, be able to prohibit exercise of the right. That might be the sensitive places doctrine, for example. But they can't exercise the police power in a way that broadly stifles the right. And to broadly stifle the right is to infringe the core of the right. And so you have to know where the core and the periphery are. Larry, I mean, I will work on moving that up, and all those suggestions are very helpful, including, I mean, you're right, too, that I don't really use the language of original public meaning, and I think I could add that in terms of the pragmatic enrichment, as you note. So thank you for those suggestions.
So there's a lot here that's very interesting. I found myself interested in the question, on your view, the relationship between the militia and the state, where state is polysemous, right? What do we mean there by the state? There was a point where you said people in the founding generation weren't opposed to national armies, they were opposed to standing armies. That sounds right to me. But you also said the militia is not a state army. And I thought, well, it's not a state standing army, but is it a state citizen army or some other sort of thing? And here's the line that I thought you were playing on both sides, or maybe this is just a way to crystallize. The predominant definition in sociology and political science of a state in the generic sense, right, not in the US constitutional sense, is Max Weber's, right? A state is an entity with a monopoly on the legitimate use of violence. And I wonder if, on your view, the relationship between the militia and the state in the sense of Pennsylvania is such as to make Pennsylvania not a state on the Weberian definition, or a reason to think that Weber got wrong what a state is, or some third thing?
Yeah, thank you very much for your paper, and I agree with it very strongly. I wanted to just first echo the perhaps the propriety of saying something about privileges or immunities clause, 14th Amendment. Even just in the introduction, say I'm speaking about the Second Amendment exclusively. I mentioned this to you privately when we discussed this before, but I think that to say the conclusion may mention the privileges or immunities clause because it strongly supports your approach. If we think of it as the rights of members of a community to act in connection with their community, if the privileges or immunities clause is the mode of incorporation, at least the 14th Amendment is consistent with your approach. It's not fundamentally a natural right of self-defense. It's fundamentally a right of members of the community to do things for the community. Secondly, about that distinction between the community and the individual, if it's true, and my own far less significant, substantial research suggests that there's not a lot of people in the 19th century thinking those things are really two different and distinct things, such that state constitutions can say both or state constitutions can say common defense. Maybe I'm rushing to a conclusion here, but at the very least, it wouldn't be crazy to say, well, of course, that's not really a problem because citizens are members of the state, getting to what Richard Prime has said, that is to say, the state is not different from the citizens because the citizen is a member of the state by definition. So you don't have to specifically enumerate that a citizen in providing for the common defense provides for himself, because that's what, that would be your first order of business, okay? What part of the state do I take care of? My home, my family, my body, and then others. And third, I can't resist on this in terms of the continued relevance of an armed citizenry to resisting tyranny. This is from the Mexican internal deliberations when they got the Zimmerman note in 1917 about should we take up Germany on their offer to go to war with the United States. And first they said we can't win again the military, but they said even if by some chance we had been to win the conflict, it would have been severely difficult conquering and pacifying a large English-speaking population, which had long enjoyed self-government and was better supplied with arms than most other civilian populations. And that goes to a kind of, not we're going to win the pitched battle, but we're not going to let your government look like an ordinary government. It's the violence and the brutality of your rule is going to be on a daily basis. And it's in that sense that an armed citizenry is a bulwark against tyranny.
Adam.
I think it kind of throws the paper a little bit when you're agnostic on the individual rights component of it. And so hopefully that's like a second paper. I think it's a really valuable contribution, though, to reorient the right around this common defense reading. And you kind of marshal a lot of the evidence for the collective rights reading and the militia reading into this common defense reading, and then show how that's an individual right still to rebut the collective rights reading from a new angle that reorients us in the founding and to the core of the right. And so I think that's a very valuable contribution. And then by remaining agnostic on the individual right, maybe you persuade collective rights readings, people who have a collective right reading that, oh, actually all the evidence maybe is towards this common defense reading, even if that doesn't support Heller. But then I'm wondering if the second paper will be that this common defense is the core of the right, the main theory, and it's sort of an umbrella under which the individual right to self-defense naturally follows. And so I'm wondering if the second paper will be some kind of, this common defense is the core, but then it follows that Heller and Bruin are rightly decided, or the individual right to self-defense follows from that. But then kind of a critique of the idea that the common defense is the core of it, but self-defense against a crime is somehow like not at the core. And I want to maybe push back on that and ask if you actually think that individual right to self-defense against crime is not part and parcel of the common defense, that an individual's right to protect themselves against criminality is not part and parcel of, we can get together and we can form a posse comitatus and we can stop a criminal gang, but I as an individual can't stop an individual criminal. It seems like maybe the self-defense is even more to the core than the common defense. And maybe that's because the natural right is that as there's this natural rights component, like natural rights embedded in positive law, kind of these general law rights have a natural rights origin. So I'm just wondering if you actually take, it's agnostic, but I'm wondering if you actually take the view that the individual right to self-defense against crime is not at the core of common defense. If it's descendant of common defense, but not at the core of common defense.
Robert. Okay. So starting with Richard, I think the relationship between the militia and the state is one of the more complicated questions in the Constitution. I don't think the militia is attached to a particular level of government. If you go back to the Revolution, it was originally attached to the state governments. Having 13 separate militia systems was an unmitigated disaster during the Revolutionary War. And one of the central parts of agreement on the Constitution was that in principle the militia system had to be partially nationalized, and then they bitterly divided about how much. But I think the militia system came out of the Constitution as primarily a national militia system that was organized at the individual state level. So Congress handled the policy decisions, the states executed those policy decisions. It's an early example of cooperative federalism. And the states also had residual power to use the militia for their own purposes. Necessary to the security of a free state, I think in the Second Amendment, I think free state there means a free country. Madison's original draft said a free country. I don't think the change from country to state, I think that was stylistic. I don't think that meant to switch it from a free United States to a free Pennsylvania. And I don't think there's much evidence that, linguistic evidence, that the militia had to be attached to the states. Territories had a militia too. The Northwest Ordinance provided for the Ohio Territory militia. District of Columbia had a militia. Adam Smith talked about a militia in contrast to an army, and he was not talking about forces attached to the state government. And the militia existed in England, where there were no states, and as an institution stood in contrast to the standing army. So I think this idea that it is a state militia is has been a profound mistake. And a lot of the early legislation too referred to, sometimes they referred to the militia of the several states, but sometimes they said the militia of the United States too. I think it was one of these bodies that just, it was not attached to a particular level of government. To David's point, I think you're right about the continued relevance of individuals doing things on behalf of the community. And I think a classic example you can see of that today is Ukraine, too. Ukraine suddenly, in response to the Russian invasion, they had to expand their army very quickly. They had to do that by handing out arms to every able-bodied person because they don't have a right to bear arms. They were forced on very short order to try to provide for training. And because they had no right to bear arms, they became dependent on foreign suppliers. They had no domestic arms industry, and they did not have a population that had a right to their own weapons. And so that made them totally dependent on foreign suppliers, which I think is very dangerous for a government because foreign governments will act in their interests, not in yours. And so having individuals who can be prepared to come to community defense, I think, remains a very relevant thing. We don't notice it on a day-to-day basis because the chances of, going to war with a pure threat, those are rare occasions. But that doesn't mean it's not relevant, because when it becomes relevant, countries often have to scramble. And we were very fortunate in both world wars that Europe went to war years before we did, and so we had time to adapt. But countries like Ukraine don't always have time to prepare. Sometimes they have to mobilize on short order. And then in terms of does individual self-defense follow from common defense? So I think there are two answers to this, yes and no. And the yes part is, I think active self-defense against active threats are intimately related to common defense because, again, any act of individual self-defense can also be repackaged as a law enforcement action to prevent a forcible and atrocious felony. But I think the broader individual rights question is whether there's a right of preparatory self-defense. Can you arm yourself not while you're actively engaged in self-defense, but on anticipation that may become necessary? And I think the answer to that is yes, but again, I think answering that question requires a separate kind of justification than merely deriving it from the common defense. I think some individual self-defense gets derived from common defense, but not all the way to Bruin.
So my question is, I want to bracket the first theory of enabling an individual's self-defense against crime, and you were talking about one reason, if we have the common defense model, why we might assume that we don't have enough guns for government to provide, to go to your second point of your thesis, that government has to be able to provide those guns, is because if we went to war with someone like China or Russia, we would need a lot of guns. But just if it were empirically true that, in fact, we have, like the military has enough guns to provide to the Army such that it can satisfy that second prong of your thesis. The slide, if you could just go back, it's the slide before this. So,
wait, slide before?
Maybe it's the first slide. Anyway, because the thing, yeah, the arms must not otherwise be adequately supplied by the government for private purchase or possession. So let's just assume empirically that the government already has the guns that they need if we went to war with Russia or China, because in fact what we will really need if we go to war with Russia or China are drones, and that's going to be how most of the warfare is operated. And so it's not like there will be some people using guns, but that was not going to be the mass of how guns are operated, or pick some other weapon. But like, just if that were empirically true, does that undermine your claim that for arms to support the common good, people don't need to keep their own arms at home? Maybe government could provide drone training practice for people. I don't know, but do you see what I'm getting at with that?
I see what you're saying. I'm going to fight the hypo a little bit. I think questions.
No, to answer the hypo.
I'm going to fight it a little bit because I think this is one of the common moves that collective rights theorists make. They're like, we have airplanes, who cares about this? And what people are really saying with this is that the infantry is obsolete. And anyone who looks at modern warfare can tell that the infantry is obsolete. I mean, what's the one thing Ukraine is running out of? It's infantry soldiers because of the, because they are ultimately drones do not secure and hold territory.
I'm not saying it's obsolete. I'm just saying it is only part of how you perform warfare. And so
so that's undoubtedly true, that it's part of how you perform warfare. But actually exercising sovereignty requires somebody on the ground with a gun. You can't do it with a drone. You can't do it with an airplane. You need someone to occupy the territory and give binding directives to the population.
Sorry, I wasn't quite done asking my question.
Sorry.
The other part of my question was going to be, can you just explain in one sentence what it means to interfere with the core of the right? Because I think that's a persuasive argument you're making, but put it in concrete terms. Like, what would it be to interfere with the core of the right?
Okay, yep. The second is, even if the government had enough arms in the abstract, preparing for war is a perishable skill. Shooting, being able to shoot accurately is a perishable skill, and it requires a fair amount of training over time. And so even if the government had the arms in the abstract, private possession is still relevant because people need to prepare on their own. I've been trying to figure out, I don't think it's actually well studied how much training is necessary to make people proficient for war. I asked the FBI what they do, and they do 4,000 rounds of ammunition per agent. That's what they think is necessary to bring somebody up to a level of proficiency. I mean, you can imagine if we had to train 10 million people from scratch, the resources that it would consume, not for frontline service, but just for training. And so private possession helps bridge the gap, not just so that the arms are stored in a warehouse, but people retain active military knowledge so that they can enter temporary military service and then go back to civilian life. And then with respect to the core of the right, I think the core of the right is doing what Randy and what Evan Bernick was suggesting in the, when they were talking about spirit, that rights are teleological, and you hit the core of the right when you make the right incapable of performing its function. And the core function here is, I think, at least the ability of individuals to do military service. And so, again, bracketing the individual self-defense question, a police regulation that said no rifles hits the core of the right because it makes people incapable of performing military service, even if other weapons like handguns and shotguns are available. And I think this is why it's so significant how you conceive of the core of the right, because whether there are adequate alternative weapons depends on what you think you're doing. Are you just defending yourself or defending the community? And that, in turn, profoundly influences the scope of the police power.